Great. All right. So from here, I will talk in Japanese. 本日のトピックですけれども、まず最初に著作権保護についてご説明申し上げまして、その後、著作権侵害について説明させていただきます。侵害の要素について何があるかをご説明して、その後、どんな救済方法があるかについても述べます。さらに、3番目なんですけれども、実際の最高裁の判例であるアンディ・ウォーホル対ゴールドスミスという事件をとって、フェアユーズについて説明させていただきます。よろしくお願いいたします。まず、著作権保護の、規定なんですけれども、米国著作権法の106条にあるように、著作権者にはいくつかの権利が与えられています。まず、著作物を複製する権利。著作物から派生した著作物、ものを作る権利。著作物をディストリビュートする権利。著作物を公にフォームする権利ですね。著作物を公にディスプレイする権利。さらに、著作物をデジタルオーディオトランスミッションによって公にパフォームする権利を持っています。例えばですね、私がもし絵画を作ったとしますと、私は第三者の方が私の絵画を勝手に展覧会で展覧してしまうことを妨げられるわけですね。ですので、その場合私は著作権者として連邦の著作権を登録した後に、レジストレーションを行った後に、連邦夫妻に著作権侵害の訴訟を提起することができます。ただし注意しなければならないんですが、著作権というのは、永久的に存在するわけではなくて、一定の期間でしか保護されません。著作者のオーサーの死亡から70年間、職務上の著作物については、最初のパブリケーションから95年間、あるいは著作物の創作の時点からですね、120年間というふうに限りがあります。で、私がこう言って、米国で何か著作物を作った場合には、大体の国で著作物に基づく権利を行使することができます。というのも、世界中の多数の国々がトリプス条約に加盟しているので、トリプス条約の加盟国においては、いろいろな、著作物の権利の保護の法制度がございます。次のスライドに行きます。と、著作著作権侵害で、例えば訴訟を提起してしまったとします。その場合に私が著作権者、つまり原告としてですね、立証しなければならないのは2要素になります。まず1つ目の要素は、私がコピーライティッドワーク。コピーライティッドワークというのは、著作権によって保護されている著作物を有しているということをまず証明することが必要になります。次に、著作物を勝手に複製したり、あるいは勝手に派生した著作物を作ったりとか、あるいはディストリビューションをしたということを証明する必要があります。まず第1点目に関してはですね、例えば、被告が私の著作物を勝手に複製したことを証明するとします。その場合、私は実際には被告が私の著作物をアクセスすることができたという事実ですとか、あるいは被告が私の著作物について、インプロパーアプロプリエーション、不適切なほどに使用してしまった、不正に使用してしまった、不正に使用してしまったということを証明する必要があります。この2つの事実ですね、結構大変なんですけれども、一応、被告の著作物をよく観察することで、こういった2つの事実を立証することができることがあります。実際にはやはりエクスパートオピニオンなどを使って、こうした2点を立証することになります。 点目ですけれども、私の第1点目ですね。コピーライティッドワークについては、私の方で、まず私の著作物が有形物に固定されているっていうことを示す必要があります。例えば私が、まあ、絵画を作った場合には、キャンバスに絵を描いているわけですから、それでこの要件は満たされます。で、2番目に、ですね、私の著作物がオリジナルなものであること、他の人に取られてないということを示す必要があります。まあ、誰かの、まあ、流用品ではない。私ならではのユニークな著作物であるということをちゃんと証明しなければなりません。で、さらに、著作権法によってちゃんと保護されていることも立証することが必要になります。例えば、最近ニュースになりましたけれども、ミッキーマウスの、まあ、こういったキャラクターについては、95年間という著作権法の権利期間がすでに経過してしまいましたので、もう著作権法に基づく保護が終わってしまいました。ですので、誰でもこのミッキーマウスの、まあ、キャラクターを使うことができるようになるわけですけれども、まあ、パブリックドメインにミッキーマウスの著作物については入ってしまったというふうに言われています。はい。で、次にですね、著作権法に基づく著作権侵害行為を被告がしているというふうに、私が無事証明できたとします。そうしますと、米国著作権法上は以下のような救済策が与えられることになっています。まず一つ目は、損害賠償になります。損害賠償は、まあ、一般的に求められるのは、原告が実際に被った損害、あるいは被告が受けた利益、そのいずれか大きい方を原告としては求めることができます。またその他にも、著作権の法の規定に基づくスタチュートリーダメージズっていうものをリクエストすることができます。ですので、スタチュートリーダメージズの場合は、私、原告自身の損害額ですとか、あるいは被告の利益とかに実際証明する必要がなくて、法文上の一定の額に基づいて、その指定されたような範囲の損害賠償を求めることができます。ただ注意していただきたいのは、さっき申し上げたように、著作権法には期間が限られておりますし、あるいは、まあ、消滅時効として3年間ということが言われていますので、侵害行為から3年以内にこうした救済措置を求めなければならないことになります。まあ、さらには、弁護士費用も、勝訴した原告には与えられることがある。また、原告は、エクイタブルメディ、つまり、差し止め命令を求めることも可能になってきます。もちろん、これは一定の限定がありますけれども、救済としては与えられることは、立法上は可能になっています。はい。以上が、まあ、立法の仕組み、著作権保護の仕組みについてなんですけれども、実際の事件についても早速入って見てみることにいたします。今回ご紹介申し上げるのは、アンディ・ウォーフォル・ファンデーション対ゴールドスミスという去年の最高裁判決の事件になります。この事件の原告は写真家であるゴールドスミスさんなんですけれども、そのゴールドスミスさんは、こちらの左側にある写真を撮影した方になります。この写真に写っているのはプリンスという、有名なロックミュージシャンになります。で、右にあるのがアンディ・ウォーホルさんという画家が描いた、このゴールドスミスさんの写真に基づいた絵画になります。この二人がですね、ゴールドスミスさんやアンディ・ウォーホルさんが こういった作品を作った理由としては、いずれもですね、雑誌がプリンスさんに関する特集を組んで、その雑誌の中に使いたいということで、嘱託を受けて、この二人の画家さん、あるいは写真家さんがこうした作品を作ったというふうに言われています。はい。で、最初にその雑誌の発行者としては、アンディ・ウォーホルさんに対して、ゴールドスミスさんからは、写真の使用に関するライセンスを機会限りですけれども、受けているので、だから安心してこの写真を使って、このが、ペインティングを作ってくださいというふうにお願いをしています。そこでアンディ・ウォーホルさんは安心して、こちらのペインティングを作ったと言われています。アンディ・ウォーホルさんというのは非常に有名な、画家でして、こういったキャンベルスープという、まあ、トマトスープの作品を作って、どっかの美術館、確かこれはミネソタの美術館ですかね、に収蔵されていますけれども、こういった大衆が日常を使っているような物品を美術として作品の中に取り入れることで有名な方でした。アンディ・ウォーホルさんの前の画家の方々っていうのは、例えば聖書に基づく風景を題材として作品を作ったり、あるいは綺麗な女の人を描いたり、あるいは綺麗な風景を描いたりしてたんですけれども、アンディ・ウォーホルさんはそういったことではなくって、まあ、コンシューマリズムという消費者にの観点に立った作品を作ろうということで有名な画家になっています。はい。それではですね、実際にこの事件で起きたことなんですが、このアンディ・ウォーホルファンデーションさんは、ゴールドスミスさん、写真家の方のパーミッションがなく、このペインティングに関するライセンスをパブリッシャー、また雑誌の方に与えることができるでしょうかという問題が上がりました。この事件でこの問題が上がりました。で、アンディ・ウォーホルファンデーションとしては、その雑誌から支払いを受けたようです。先ほどご説明申し上げましたように、米国著作権法では、アンディ・ウォーホルファンデーションは、実際にはデリバティブワークを写真に基づいて作っているわけですから、やはり原則としては著作権侵害行為を行ったことにはなります。で、あの、まあ、一般的には著作権侵害行為に当たるはずなのですけれども、では、こちらはそのまま違法行為となるんでしょうか？いや、違うと。アンディ・ウォーホル財団の方は、フェアユーズという規定に基づいて、違法性が阻却される、まあ、違法ではないんだということを主張していました。まあ、例外規定に当たるというふうに主張したわけですね。で、このフェアユーズに関してですけれども、有名な事件が、キャンベル vs. エカフローズ・ミュージックというものがあります。この事件はどういった事件かというと、この、もともと、とうんですね。お見せしたいのですけれども、どうもします。見えますか？見えていたらいいんですけれども、こちらの、ラップミュージシャンが作ったプリティウーマンというパロった音楽に関する訴訟が起きていました。もしかしてこれを、この 事件についてはもしかしてご存知の方もいらっしゃるかもしれないんですけれども、とこちらの事件でラッパーであるキャンベルさんたちが、まあ、最初はこの著作権を持っているエーカフローズミュージックっていうところにライセンスを求めたんですけれども、そんな内容の著作物を作っては困るということで、ライセンスを拒絶されてしまいました。しかし、それにもかかわらず、作ってしまいました。先ほどのようなパロった音楽を作ってしまったんですね。で、オープリティウーマンっていう、歌なんですけれども、非常にロマンティックな、ロック、バラードっていうふうに言われるジャンルの作品なんですけれども、作った作者に対して批判的な、リリック、えっと、内容でコメントしていて、その歌の内容がですね、なんて、ありふれたようなリリックなんだとか、いや、なんか本当に、くだらないようなことしか言ってないよね、みたいなことを、このラップ、ラップミュージシャンの歌の中では言っているわけです。でとってもシニカルな内容になったソングでした。この事件でもですね、やはり、このラッパーのソング自体はデリバティブワーク、派生物です。派生した著作物ですので、やはりコピーライトインフリンジメントに当たると考えられます。ですけれども、これが本当にフェアユーズとして違法にはならない行為なのかについては、かなり意見が分かれました。第一審は、これはフェアユーズだと。これはかなり、批判的に、あの、描くことがメインの行為なので、トランスフォーマティブなものである。トランスフォーマティブなユースであるっていうことに注目して、フェアユースが該当し、違法ではないというふうに判断しました。しかし、上訴された、シックスサーキットでは、キャンベルさんたちに不利な判断となり、フェアユースは当たらないよというふうに判断されました。フェアユースの規定は、107条の規定なんですけれども、107条には4要素が上がっています。4要素としては、この被告の使用がどんな目的か、あるいはどんな性質だったかということを見なければならないというふうに言われていまして、2番目には、著作物、コピーライトで保護されている著作物がどのような性質のものであるかということも判断しなければならない。考慮に入れなければならないと言われていますし、また、オリジナルなコピーライトで保護された著作物のどのぐらいの分量、どのぐらいのエッセンスを被告の方で使ってしまったかっていうことも判断しなければならないというふうに書かれています。また最後にですけれども、被告の使用が著作物のマーケット、今後の、著作物の収益に与えるような影響はどんな風になるのか、それを考慮しなければならないというふうにも書かれています。で、こちらの4要素について、最高裁の方ではいろいろと見ていったんですけれども、まず、The purpose and nature of the use is different from the original. つまり、元々の著作物の目的や性質とはかなりラップミュージックの方は変わってしまっていると、トランスフォーマティブだというふうに考えています。まあ、確かに、ラップミュージックの歌自体はコマーシャルパーパスであることは否定できないんですけれども、商業的な目的であることだけで、公正な使用に当たらないとすることはできないというふうに判事されます。で、2番目の要素である、オリジナルワークのネイチャー、性質については特に、被告にも原告にも有利になるとは考えられませんでした。で、3番目ですけれども、amount and substantiality of the caution used については、かなり音楽としては大きな部分を使われていますし、また、最初の一番目立つような部分、歌の最初の冒頭の部分を流用されていることで、結構大変な部分を使われたんじゃないかっていうふうに 原告の方は主張していました。あ、また失礼しました。で、あとですね、The effect on the market of the original work ですね。こちらは、まあ、ラッパーが作ったソングが売れたことでですね、ラッパーの音楽を入れてしまったことで、元々の音楽の作曲者に対して何か影響を与えてないかということがまた、はい、あの、考慮されたんですが、そんなに大した影響を与えてないんじゃないかっていうのは、そもそもラップミュージックを買うような人たちは違った層にあるだろうし、そもそもラップミュージックがすごく売れたのは、そういったトランスフォーマティブな点がむしろこういったヒットをあの、原因になったんじゃないかということで、まあ、最高裁の方は考えて、こちらのケースについては、フェアユースに当たるというふうに判断いたしました。はい。ですので、このキャンベル対コス・ローズ・ミュージックの事件によって、パロディっていうものが、もともとの作品をパロったものがですね、フェアユースとして認められる余地がかなり広がったと言われています。ですので、アンディ・ウォーホル・ファンデーションにおいても、やはりこのキャンペル対アコースローミュージックのように、パロっているような、あるいはトランスフォーマティブな目的、あるいは必要に当たるんじゃないかということを主張したわけです。ゴールドスミスさんとしてはですね、原告としては、アンディ・ウォーホルも、あるいは写真家も、どっちも似たような商用目的で作品を作っていて、似たような性質を持っているじゃないですか。だって雑誌にそもそも載せられるということが目的で作品を作って雑誌に対して売っている作品のライセンスを与えているということなので、これがやはりフェアユースに当たるとすることは許されないというふうに主張しました。他方、アンディ・ウォーホル・ファンデーションの方は、トランスフォーマティブだ。見て、考えてみれば、アンディ・ウォーホルというのは非常に大衆化するような芸術家であって、プリンスの写真自体とは全く異なった美術的な意味を与えるんじゃないかっていうふうに、depicting celebrities as commodities。つまり、プリンスが人間を超えた、あるいは大衆的な消費物というふうに描かれてしまって、芸術的な意味の、あるいは消費者に与える意味もかなり違っていますよね、というふうに主張しました。こういった芸術品の作成行為については、やはりフェアユースで保護すべきではないかというふうに主張しておりました。で、この事件の第一審であるディストリクトコートは、やはりウォーホルはプリンスの作品をトランスフォームしてしまっているので、これはコマース、コンスューマライズ、コンスューマリズム、コンスューマライゼーションが起きたと。vulnerable uncomfortable person がアイコニックで larger than life figure に、この芸術によって変化されていますよということを認めて、ディストリクトコートはフェアユースを適用いたしました。最高裁はですね、結局、ゴールドスミスさんに有利な判断をして、二人ともやはり雑誌社に対して、プリンスさんに関する特集に使われる写真や海外を提供したので似たような目的だし、使用の性質も似ていると。で、かつ、アンディ・ウォーホル・ファンデーションとしては、まあ、コンビンシング説得力のある、正当化ができていないですね。というふうに判断いたしました。この写真ですが、このスライドにある、写真は、最高裁の判決に使われた写真です。左側が、ゴールドスミスさんの写真で、右側が ゴールドスミスさんの写真の上に、アンディ・フォーフォルさんの絵画をポコッと載せているんです。確かに、最高裁の多数派意見の通り、まあ、非常に似ている。なかなか、区別できないような似た点がございます。しかし一方でですね、反対意見もありました。そ、ヘイガン最高裁判事とジャスティス・ロバーツは反対意見を提出して、そもそも最高裁としては芸術の作品の作成目的なんかわからないんじゃないかというふうに反対しております。また、古い芸術に刺激を受けて新しい芸術を作るという行為をもっと尊重すべきではないかということも意見でお書きになっています。The fact that consumers like Condé Nast would value the aesthetic differences between the two pieces demonstrates that Warhol had effected a transformation というふうに結論しています。まあ、これも反対意見の中で引用されているんですが、こちら有名な、えジョル、ジョルジ、イタリアのペインティングがありまして、こちらの非常に有名な絵画に基づいて、ティタンという、この最初の絵画の画家さんの下で修行していた人が、本当によく似た絵画を作りました。で、この3番目、こちらマネの、同じようなやっぱりヴィーナスの絵になりますけれども、版画の女性の絵になりますけれども、これもやっぱりこうした2つの絵画に影響を受けて作られたものですので、まあこういった、絵画を引用しながら、こちら反対意見の最高裁判事はこういった、画家が自由に昔の作品に基づいて作品を創出する機会を損なうべきではないというふうに結論されています。はい。これが、アンディ・ウォーホル・ファンデーション対ゴールドスミスという去年の最高裁の判決になります。この判決次第がコピーライト関係の訴訟に与える影響は、もしかしたら非常に大きいかもしれませんし、もしかしたら大きくないかもしれません。こちらは今後の判例の展開が待たれるところになります。冒頭で申し上げましたように、著作権をめぐる紛争というのは結構多数国間で紛争が起きることが多いです。と言いますのも、トリプス協定に基づく保護が及ぶからですね。まあ、アイアクトのようなアービトレーションセンターであれば、まあ、グローバルに訴訟あるいは紛争を解決できますし、また早くかつ費用も効果的に紛争を解決することができますので、今後、皆様の方でご活用いただけるかもしれません。どうぞ、念頭に置いておいてください。はい。では、ちょっとチャットの中に、一部。はい。ありがとうございます。問題性についてもパーミッシブルか否かという問題設定の際、講師の男性自体がコピーライトに文句あるのでしょうか。もしながらば、文脈冷静に来た問題さえ。はい。ですね。つまり、あの、そもそも、こちらのアンディ・ウォーホルさんの派生物、こちらについてはですね、派生した著作物、デリバティブワークについては、原作者の許可がないとそもそも著作物として保護されません。で、著作者の許可なく、やはりこういったライセンス行動をするということは、やはり原著作権の侵害に当たるというふうに言えます。つまり、この作品を作った時点では、確かに一回限りのライセンスを受けていたので、作った時点では確かに作って、かつ つの雑誌に対して投稿する分には良かったんですけれども、それを他の雑誌に投稿することについて、やっぱり問題が残るということで、ライセンスではカバーされませんでした。はい。ご質問いただきありがとうございました。まあでも、こういった、背景事情があって、最高裁も、あの、フェアユースが及ばないというふうに考えたかもしれませんので、さすがいいところに、ご気づきいただいたかなというふうに思います。次回の、ウェビナーですけれども、4月5日金曜日の6時から7時、日本時間で4月6日の7時から8時になりますので、また、Iact Tokyo.com イベンツ、こちらのリンク先、ウェブサイトからまたお申し込みいただければと思います。次回はジョン・ジー・スミスさんという、フェガー・ドリンカー・ビドルという事務所のパートナーの方から、特許の相続期間、パテントタームアジャストメントという非常に重要な論点についてご説明をしていただくことができます。を予定しております。よろしくお願いいたします。以上が、第1部の発表になりましたけれども、他にはご質問ないでしょうか？それでは私の方は画面の共有を停止しまして、すみません。はい。はい。で、また、こちら、続きを、ライアン・アボット先生の方から、第2部として AI インベンション、AI のデリバティブワークについてのご発表をお願いしたいと思います。ライアン・アボット先生、よろしくお願いいたします。
Hi, Kumiko. Is that my cue?
I can hear you. Thank you.
Oh,
Thank you
yeah,
so
very
much for
good.
joining.
Well, no, it's my pleasure and honor to be here. And I'm afraid I did not get a whole lot of that last presentation, but the slides being in English were helpful. And looking forward to speaking with you all today. And I'm going to try and leave some good time for Q&A because I think it's more engaging and, would be good to have this be a bit more interactive. But I will, for a starter, get going with the presentation I prepared. And I'm going to talk a bit about intellectual property and artificial intelligence and get a focus on intellectual property rights for AI generated output, and in particular, copyright and patent law. And it is interesting that, AI has been making content in whole or in part for a very long time, the 50s or 60s, really. But largely only computer scientists who had a theoretical interest in it or law professors who had a theoretical interest in it paid attention to this. And that dramatically changed with the release of very capable LLMs in the past couple of years, the large language models like ChatGPT, Google's Gemini, Midjourney, those sorts of systems, because while you could have an AI write an article or a book or make an image or a painting before, it was always very bad. And now it has gotten to the case where sometimes it is really not easily distinguishable from something that a person can make, and it can really make it very quickly. And to give an indication of how much this has jumped to the public consciousness of things, last year in Los Angeles, where I am largely, the Writers Guild went on strike, and they claimed that a major reason for their strike was the use of artificial intelligence in the creative industry. Not, a reason or something they were concerned about, but a major driving force. Now, to be fair, some of this is concerns about technological unemployment, AI putting people out of work. It was largely sort of concerns about labor practices. So the writers were concerned that studios would have an AI write a movie script and ask them to fix the script. And if it was done that way, they wouldn't have to pay the writers the same way as if they had them write the script from scratch. Or some actors had reported coming to casting calls and reading lengthy scripts and having a lot of videos taken of them. And then they would appear later in movies that they had not been aware of as extras. So the Writers Guild ultimately kind of largely triumphed in the strike and got a lot of concessions from music and movie studios about how AI would be used. The disruption that AI is going to cause is now fairly well appreciated. It's really top of mind for policymakers around the world. And the most significant thing being, in terms of policy in the past month, that the European Union has now adopted the EU AI Act. So this is the first major jurisdiction to adopt an AI-centric set of rules. And it only has a little bit to do with IP. For example, there are requirements around disclosing training sets for AI and the copyright status of that and so forth. It more is a risk-based regulation, but this is still kind of a major milestone in AI regulation. And different jurisdictions like the US and Japan have been handling this in different sorts of ways. And AI generally is on people's radar. AI and IP is also very much on people's radars. So in the past 5 years, intellectual property offices have taken a great interest in this. They've run public consultations, they've published reports. The first of these in this kind of new wave was in 2019 by the US Patent and Trademark Office that issued 2 requests for consultation or requests for comments on AI and patents and then AI and other forms of intellectual property. And they basically published a report that said, nothing new here, this will all be fine. As of a few months ago, they were now doing a consultation just on AI and joint inventorship. And as we'll talk about, have now published a very complicated guide about how joint inventorship could potentially, factually, even lead to unpatentability. So in just 5 years, people's thinking about this has evolved very sharply. And I think that is due to a combination of advances in AI we've seen in the past 5 years, the widespread accessibility of creative and inventive AI systems, and some of the case law and some of the debates that have been going on during this time. And there's a lot of very interesting intellectual property issues associated with artificial intelligence. For example, there's a company called Clearview that makes AI that helps law enforcement with facial recognition. And they have trained their AI on 10 billion photographs scraped from the web. So if you're on Facebook or Instagram or TikTok, you're in the system somewhere. And, this has all sorts of concerns about security, privacy, contractual rights from scraping data and user terms online. And of course, from copyright, with whether that sort of activity is prohibited by copyright law. Also in the news very topically is synthetic content or deep fakes. These are 2 pictures of the Pope, only one is real. The clue is he never actually wore a Balenciaga jacket. So that's the picture of him in the fluffy coat, though he does look pretty good in it, I think, to be honest. And, while we've been able to make synthetic content of people for a long time, what has changed is there are now apps on an iPhone that can do this for you. There are apps that are publicly available. People with a little bit of technical sophistication can now make something like this. So it's no longer something that requires a very high intensity of effort. And the Pope is pretty innocuous, but this was an image that came out around the time of Donald Trump's first indictment. It's not a real image, but you could imagine how easily, and the technology's improved a lot since this image came out. Someone could start propagating misleading, politically sensitive information online. And of course, people are doing this for money. So Bruce Willis has been appearing in advertisements without his permission. Tom Hanks has as well, a number of other stars. And this is something that is also top of mind for policymakers and is top of the agenda for right holders and music and movie studios. And they, in the United States, laws about whether someone can use your name, image, likeness, voice for commercial or non-commercial purposes without your permission is largely a matter of state law. And there are discussions right now, and there are federal bills introduced to have a federal right of publicity. Tennessee just passed the Elvis Act, which prohibits someone from making synthetic content of you essentially without your permission, and also makes it a criminal offense to do so. And it doesn't distinguish between commercial and non-commercial purposes. So this is because Tennessee, is the home of Nashville, where, music is one of their major exports. And so this is an industry that they have been very sensitive to lobbying from. And of course, it raises other interesting sorts of questions. Chat GTP works by statistically estimating what word should come after what word. So it is very good at knowing, for example, when a citation should appear and what a citation should look like. But it's not so good at knowing whether the citation is accurate or whether a stated proposition is supported by the citation. So if you ask whether, I have been accused of any wrongdoing, it may tell you that I've been accused of murder and cite to a New York Times article, but that New York Times article may not exist. And so this raises all sorts of other interesting questions about free speech, speech by machines, defamation and libel rules around this sort of thing. And of course, attorneys in the United States are now routinely caught turning in briefs written by ChatGPT, citing cases that don't exist and getting punished for that, because professional rules in the United States require that lawyers signing a submission to a court validate that all of the citations are accurate. And these lawyers are just turning in things that it is puzzling that people still do this, but people still do this. That's a little bit of an overview. I want to dig a bit deeper in a couple of areas, one on the protectability of AI generated works. And I'll define that as a work made by an AI without a traditional human author. And this is something that has been discussed again for a long time. The United Kingdom was the first country to make an explicit rule about this. So in 1988, so this was now 35 years ago, the UK amended the Copyright Act to provide that computer-generated works were protected by copyright. They get a shortened term of protection, 50 years from the date of creation, rather than 70 years from the life of the author. And the producer of the work, the person who undertakes to have the work created, is deemed to be the author. So that was done because in the 1970s and 80s, the British Computer Society thought that if there was not a rule on this, there would be widespread uncertainty in the creative industry. And that turned out not to be the case. But 35 years later, that's the case in the United States and some other jurisdictions. So there's no statutory rule explicitly in the US, but there has been a Copyright Office policy since 1973. And that policy is that if a work lacks a traditional human author, you can't have copyright protection. And in support of that rule, the Copyright Office cites to two cases from the 19th century, so long before the development of modern computers, including this case, Burrow-Giles v. Cerrone, which involved a famous picture of Oscar Wilde shown here. And in that case, the US Constitution protects the writings of authors for copyright purposes. And the alleged infringer argued that a copyright could not subsist in a photograph. And the reason for that, they said, was this is not a writing, and literally it is not a writing. It is a mechanical reproduction of a natural phenomenon. And I think we've got someone who's unmuted. Kumiko, if you might mute them, as I think they're on the phone. Anyway, the Supreme Court reviewed this and decided to interpret writing purposively rather than literally. Kumiko, is that a question or do we need to mute
I
someone?
don't think it's a question. I think, he's on the phone, probably.
Can you mute him as the host?
Wait, I will.
Yep, thank you. Oops. So the Supreme Court in this case held that really any tangible means of expression by which an idea in the mind of an author is expressed is eligible for protection. And the Copyright Office has interpreted this to mean that machines don't have minds, and therefore you can't protect what comes out of them. And for the longest time, there was never a case on this. Sometimes people would say things like, well, yes, I wrote this book, but it was channeled by my dead grandmother or by Jesus, so I'm not really the author. Those are interesting, but a little bit different. There was this case of the monkey selfies. So this is a picture taken by a black-crested macaque of himself. His name is Naruto, and he's smiling in the picture, and people thought this picture was adorable, and there was a commercial kind of interest in it. He's actually smiling because macaques smile is a display of aggression. So he was probably seeing his image reflected back in the camera lens and trying to intimidate that monkey. But in any case, people thought that this image was, adorable. And the camera owner tried to threaten them with infringement and said, this is my photograph and I own it and I'm the author. And in an early version of the story, he had left the camera lying around and the monkey took its own picture. And in a later version of the story, he had carefully studied the monkeys and induced the monkey to take its own picture. But what was undisputed was a monkey took this picture. And this got so much public attention that the Copyright Office amended and restated their human authorship requirement to state that, among other things, photographs taken by monkeys could not get copyright protection. There is actually a small market, commercial market for animal art. But that seemed to be the end of it until PETA, People for the Ethical Treatment of Animals, which is a nonprofit organization on animal rights, sued the camera owner in federal court and alleged that the monkey owned the picture, not the camera owner. That case was dismissed, but it was dismissed based on standing. The court said, unless Congress is very plainly going to tell us that monkeys can bring lawsuits, monkeys can't bring lawsuits. So now we get to modern times, and people are using generative AI systems to make art left and right and submitting it for copyright registration. So this is an image called Space Opera, and it was submitted to a state art fair in Colorado and won first place. And after winning first place, the artist said, well, I used Midjourney to make this, and people got very upset. He had meanwhile submitted this to the Copyright Office and successfully received a copyright registration. So Kamiko may have spoken about this earlier, but in the US, you don't have to register copyright to get protection, but it is essentially required if you want to sue for copyright infringement. And it creates the ability to get statutory damages, which are, what makes copyright infringement generally so valuable as a cause of action. The Copyright Office found statements that he had made on social media that this was AI generated, and they revoked his registration. And he wrote and said, listen, really, I made this. Like, I used Midjourney, but I prompted it. I very carefully prompted it. I iterated with the prompts, and I edited the thing that came out, and I selected the image. And the Copyright Office said, no, any element generated by a generative AI system, you cannot copyright. So this is an image from a case that I am bringing as counsel. It's called A Recent Entrance to Paradise, and it was made by an AI system in 2014. And the argument is that nowhere in the Copyright Act, the Copyright Office refused registration for this, and we're suing to overturn the Copyright Office's decision. Nowhere in the Copyright Act does it say that an author has to be human. In fact, to the contrary, under US law, although this is internationally an outlier, corporations can be authors or any sort of artificial person. And when that is the case, there is not even a requirement to disclose a human being or a contribution by a human being. And so we argue that there is nothing inherently human about the originality or authorship requirements, and therefore an AI-generated work should be protectable. And the district court disagreed and said that, human authorship is a requirement for copyright protection. And we are appealing this now to the DC Circuit Court of Appeals. Both sides have now filed an opening brief. If anyone is interested in seeing it, it is at artificialinventor.com. And our reply brief is due in a couple of weeks. Now, we listed the AI as the author of this piece, and it was not to give an AI a right. An AI is not a legal person, so it can't own property or have rights. It was listed as the author to be transparent that this was an AI-generated work. And we argue that the owner of the AI should own the copyright in the work under common law principles of property ownership. For example, if you own a 3D printer that makes a physical painting, you make that painting. If you own a digital computer that makes a painting, why should you not own that painting as well? It is fundamental that you own property made by your property, and that applies to tangible things like fruit and animals, and it applies to intangible things like interest and cryptocurrency. So that, or we allege that under the work for hire doctrine, the AI's owner can be considered the author by virtue of owning the agent that made the artwork, right? Or that you could have authorship vest in the AI's owner, without having a traditional human owner, because the work should be protectable and there needs to be an author. So we will see what the DC Circuit Court of Appeals says on this, but it is an ongoing case. And there are about 20 kind of high profile AI and copyright cases right now, although they have various causes of action, but they're largely related to infringement issues associated with machine learning. So these are images from a complaint filed by Getty Images, which is a large international right holder against Stability AI, which makes a generative AI system. And you can see that Stable Diffusion seems to have been trained on Getty Images because on the right is a image from Stable Diffusion and on the left is a Getty Images. And aside from the similarity in the pictures, you can see a distorted watermark present. So this litigation is going on in the US and the UK right now. And in the US is probably going to come down to whether this is a fair use. The US has a broad, as Kumiko spoke about, fair use exception. Other jurisdictions like the UK have a closed list, have very limited exceptions for text and data mining. Japan famously has a very broad exception for text and data mining that I understand would probably allow this sort of thing, or at least the training. But these are very important cases. It will probably take a decade for the US Supreme Court to definitively weigh in. In and on the meantime, there is a lot of risk for businesses deciding what to do with this and a number of strategies being adopted. That's a bit on the copyright front. I wanted to also touch base a bit on the patent front and the same similar sort of issue. What happens when you have patentable or otherwise patentable AI generated output? So this is an image from a talk given by Siemens in 2019. And the green thing is a car suspension, and the silver thing is a car suspension designed by an AI. And Siemens reported that they wanted to, but were unable to file for a patent on the silver thing, in part because all of the engineers involved in the project refused to say they'd invented it. They said the problems were well understood. They had AI that optimized industrial components. The value of the output was obvious, and none of them had done anything inventive. Now, Siemens might have filed anyway for a patent over their objections, but in this case, they reported they felt that they shouldn't be doing that. And so questions similar arise. Can you protect something if you don't have a traditional human inventor? If so, who would be the inventor and who would own the thing? And so also as lead counsel, I brought two cases on this, or cases for two patents, one of which was for this 3D printed device here, we call the fractal container. It's a beverage container based on fractal geometry. And a machine generated this design, and a machine predicted that it would facilitate grip, which could help someone who has grip problems drink, for example, someone with Parkinson's disease, and it would facilitate heat transfer, which could be valuable, for example, for cooling hot beverages quickly. So when we printed this, I was very surprised to find that it did, in fact, it really was very easy to grip. It is also very difficult to drink out of, and it is effectively impossible to clean unless you're drinking water out of it. But it is an invention rather than a commercial product. Anyway, we filed this application in the UK, where they did an examination for novelty, inventive step, and utility, and found that this should be patentable in a preliminary examination. And then we filed in 17 jurisdictions and a PCT application and corrected the inventorship and said, well, this was invented by a machine, and the person who owns the machine owns this patent application. And it was rejected from most jurisdictions initially. In 2021, South Africa granted a patent to the owner of the AI, with the AI listed as the inventor. And a week after that, Justice Beach in the Federal Court of Australia ruled that an AI could be an inventor, and that, at least in our case, the AI's owner had the clearest claim of entitlement to it. That decision was overturned in an en banc ruling and then did not make it to the High Court. The European Patent Office Legal Board of Appeal rejected the application, but said, in European patent law, there's no requirement specifically for an inventor to have done anything. And so there's no reason why the owner or the user of the AI cannot list themselves as the inventor. We have, as a result, refiled the application. The owner listed as the inventor. And the Legal Board of Appeal said you could even put in the specification that this was an AI-generated invention and the basis on which an inventorship was claimed. And the Formalities Division is still reviewing the application. It's been there with them for quite a while now. They may have been waiting on the UK Supreme Court decision. This came out in December. I got to argue it before the UK Supreme Court, which was great fun. The UK patent law was a little different. It has that an inventor has to be the actual deviser of an invention. It doesn't say this has to be an individual, and it gives someone a right to a patent in preference to an inventor through any rule of law. But ultimately, Lord Kitchen, writing for a unified court, held that if we want to patent AI-generated inventions, we have to law. And that the current law has as its understanding that an inventor could only be a natural person. The Federal Circuit rejected the case in I'm not sure, it was 2021 or 2022. US patent law, however, defines an inventor as an individual, and the court there held that an individual means a natural person. And one could debate that a fair bit, and we did, but that was their decision. And so most recently, just as of a couple of months ago, the USPTO has now published its guidance on AI-assisted inventions and notes that if basically you have an AI-generated invention, it is unpatentable. And that to have an invention, if it's been a substantial contribution by a natural person. And so it gives examples in chemistry and in engineering of when you could and when you couldn't get a patent, and notes that examiners should be checking the record for evidence of AI involvement, including public statements. And so I think this is really going to be a very challenging standard to administer. And also the US is places an unusual importance on inventorship. In many jurisdictions, it really doesn't matter for patentability as long as someone is listed. And there's limited grounds to challenge inventorship. And inventorship is really only relevant to entitlement, namely who owns the patent. Although some jurisdictions also have, inventor compensation, for example. The US, by contrast, inaccurate inventorship is a basis for invalidating a patent at any stage in its life. And so it is very common, almost always the case, that when someone is alleging patent infringement, that someone claims as a defense that inventorship is inaccurate. Now, at any time, as long as there was not deceptive intent, though the law is a little complicated on this, you can change inventorship, but only if inventorship can legitimately be changed. So for example, let's say a generics company was defending against a originator company for a new drug infringement, for a biosimilar or generic drug. And they argue that inventorship was incorrect. So they would depose one of the inventors at the pharmaceutical company. And if she said, look, this drug, to come up with it, I licensed an AI from Microsoft, and I don't really know how the AI works. And I said I wanted a malaria treatment, and it, generated 1 million virtual molecules and modeled all of them, and it told me that the lead candidate was the best one. So I gave it to our patent attorney. At that point, you would lose your patent. And so this has really opened up this whole new dimension of patentability concerns in the United States. And policymakers are actively considering this issue as well. A few months ago, a congressperson in Brazil proposed a law that would protect AI-generated inventions, acknowledge an AI as an inventor, but confusingly also would give the AI the patent. So I think that was a bit of confusion in the law and will be fixed at the appropriate time. And of course, very few of these laws actually, or very few of these proposed laws become actual laws. But it is something that many jurisdictions around the world are considering for statutory reform. And AI is going to change really a lot about patent law, or the way that the patent law operates, not just patentability, also things like the inventive step. So right now, to get a patent, the most challenging barrier is generally inventive step. And that is to say that an invention has to be non-obvious to a person having ordinary skill in the art, or essentially an average researcher in your field. And, courts kind of have tests for what an average researcher is. And it's a difficult test to do because it's all very theoretical and involves a lot of hindsight bias. But AI is going to make average researchers much more sophisticated because, pretty soon, instead of a pharmaceutical researcher being someone with a master's degree, or in Europe, a team of researchers, it's going to be a team of researchers using generative AI systems, very sophisticated ones that have superhuman access to prior art. So this will expand the domain of what constitutes prior art for obviousness. And it will also have superhuman problem-solving capabilities. So, for example, it could quickly draw correlations from very large data sets for existing drugs, in insurance databases to find new uses for existing drugs. And all of that means it's going to be harder to come up with non-obvious inventions. If we think about how this may play out a bit, this is an image of a monoclonal antibody, and all of the best-selling biological drugs are monoclonal antibodies. These are basically antibodies like your body makes, except just one, and copies and copies of that one, and they're made outside the body and then injected. These are drugs like Humira. And one of the interesting things about antibodies computationally is that there are a very large number of possible antibodies, but a finite number. They are just strings of amino acids in a very small protein, and there's only so many amino acids and only so many ways you can string them together. And so there's at least trillions of them, which could keep human researchers occupied forever. But there really aren't so many that you couldn't have an AI figure out every possible antibody structure and publish that online. And not just the structure, but what the antibody would be expected to do vis-a-vis binding with known targets, how you would formulate them, how you would design clinical trials, potential effects, toxicity concerns, drug-drug interactions, and so forth. And, having that sort of knowledge may make it very difficult on an obviousness perspective to get a new composition of matter patent or a new use patent on an antibody, among other things. But also if you published all that online, it might be impossible to get a new antibody patent for novelty because it's all known and published. And all of the foundational patents for biological drugs are composition of matter patents for monoclonal antibodies. So this may really radically change the way we do things from a patent perspective in biotech. And lest that sound too futuristic and unreal, 2 years ago now, both DeepMind, which is an AI company owned by Google, and Meta announced that they had their AI systems publish essentially all three-dimensional structures from two-dimensional protein sequences. And, far from perfect, but this is an attempt to basically solve a bottleneck in drug discovery. And so while this may be a very important task for understanding how proteins function with diseases involving protein misfolding like Alzheimer's disease, or how proteins will bind therapeutic targets, doing this exercise should no longer be the basis of getting a patent anymore, whereas it may have used to have been the basis of getting a patent. There's a theory in computer science called different things, but sometimes the technological singularity, as Ray Kurzweil popularized the term, though it predates him. And the basic theory is that computers will only get better and better, and human beings will not. And at some point, computers will get so good at doing things that they could do essentially any intellectual thing a person could do, including improving their own programming. And then, if that's to be believed, the AI improves the AI at eventually a runaway pace, and you get super intelligent artificial intelligence systems. And that would mean potentially a lot of things, but that AI could solve all of our technical problems, even the ones we don't know that we have. And so this calls for rethinking lots of things if and when it happens. But in patent law, for those of us who really care about patents, it would be impossible to get a patent because everything would be obvious to a super intelligent artificial intelligence system. And that was about 40 minutes from me. So we've left about 20 minutes for Q&A, and I look forward to a discussion or any questions anyone may have. And thank you very much for your time and attention.
日本語でも、ご質問していただければ、私の方で翻訳することは可能です。チャットに英語で質問をお書きいただいても大丈夫です。どちらでも質問どうぞ。Like, I think it takes some time to, put into sentence, put their questions into sentence. So, yeah.
It is no problem. And I apologize that my slides did not have text on them. But hopefully you enjoyed the alternate presentation format, some of you.
Maybe I have a question.
Yeah.
Could you explain the background to the publication of USPTO's guidance on AI inventorship? I believe there was some kind of concern or some kind of issue as a government, as by the administration. Is it possible for you to explain a little bit?
Yeah, I'm not so sure about the Biden administration's policy on it, but I can give a bit more background, right? So in 2019, the Patent Office's position, early 2020 was none of this is important. It will all be fine. As the case I mentioned made its way through the courts, the Patent Office became gradually more concerned about this, to the point where they argued at the federal circuit, this is going to keep people from getting patents. And we take no position on whether that is good or bad policy. We are just applying the Patent Act as it was written in 1952. And it was updated several times, including in 2011 on inventorship, but clearly wasn't written to address this issue, right? And following this case, they issued more requests for comments. They did a number of kind of speaking, presentations, public tours. They got a lot of stakeholder input, and they have now published this. So the Patent Office cannot make law; they only interpret law. And so the Federal Circuit's decision in Thaler v. Vidal, which was the name of this case, is binding on them. So they're presenting their view of how they're supposed to move forward under this new case law. Now, both the House of Representatives and the Senate have now held hearings on AI-generated inventions, and there is some support for protecting them. And as a policy position, the reason you would want to protect them is that patent law is designed to promote innovation, commercialization of new inventions, and disclosure of trade secrets. And all of that would be, done if you protect this, because otherwise, if you have an AI invent something, you will either have to lie about it or keep it a trade secret because it can't get a patent. Or if you have, for example, that only works in some areas. So let's say that AI makes a new very good drug. If you can't get a patent on that, you may not be able to get investment to do very expensive clinical trials. And we don't really want people not using AI in research and development because they have trouble getting a patent. But you might also not want to protect this sort of thing if what you believed patent law was for was to, encourage a very human-centric sort of activity. Congress in the United States, for those of you who have been following this, has trouble passing laws. And I think that patent law is something that's very difficult to pass laws on because it is very hard for normal people to get interested in it, as those of us who do patents could probably attest to. I did speak to the Senate on this, and they remarked that they had never seen so many young people or people in one of their hearings because it was a hearing about AI. And normally they say no one comes to their patent hearings at all. The senators all seemed to express some interest in doing something with AI, but didn't seem to know quite what, though they were all very hostile about whatever China was doing. Right now, I think the Senate is much more engaged on copyright issues, and in particular, probably more these deepfake synthetic content issues, because those are really being driven right now by right holders. Secondarily is the infringement issues on machine learning. It looked like we had a question. Yeah.
Oh, yeah. Oh, yeah. Thank you. Can you see me?
Yes.
Yeah. Thank you for the fantastic seminar. So I'm a Japanese lawyer and studying in Washington D.C. Georgetown LLM program. I just started to learn copyright law in the US, so my question might be a little bit preliminary one. So my question is about something about the authorship issue in the copyright law. And I understand that artificial intelligence cannot become an author, whereas the human beings can become an author. And I'm just curious about I'm just wondering if there is any practical benefits that we can enjoy when we specify the artificial intelligence as an author of the copyrightable work. I understand that the registration is a statutory requirement for filing a lawsuit against the infringer of copyright content. So, however, the artificial intelligence cannot file a lawsuit against infringers. So, in that case, why do people want to specify artificial intelligence as an author of the same content?
Sure. Well, to be clear, whether or not an AI can be an author is currently before the DC Circuit Court of Appeals. So it is currently kind of before the courts. No one wants to give AI a copyright or have it bring a lawsuit. The issue is whether you can protect a work made by an AI. And a work needs to have an author. And so either you could have the factual author, the AI, be the legal author, or you could have some other theory on which someone else is an author, a company or a natural person, under the work for hire doctrine, or because we're getting rid of our traditional concept of what makes an author. But just because someone is an author doesn't mean that they have any rights or own any property, right? Authors often don't. They assign their right. So, machines often generate property and they don't have rights to that property. But the reason to list the AI as the author would be because it factually was the author and to be transparent about the fact that a work is AI generated.
Mm-hmm.
You could have a different system for that. Like in the UK, you could have deemed authorship, but the US doesn't have deemed authorship. So that's why we did it that way, but it was not to give the AI a copyright. The owner of the AI has always been the person asking for the copyright.
Okay, got it. Thank you for clarifying.
No problem. It is all very confusing.
Yeah.
今何かご質問あればどうぞ。
I think Kamiko will be cold calling people if we don't get enough volunteers. So now's your chance.
Right. Yeah, I can, appoint somebody and he or she must ask you some kind of question. Yeah, but if anyone doesn't, I might want to ask you something. Yeah. I understand. So yeah, there are so many issues, especially I'm so surprised this involve our legal industry a lot. Yeah, so basically, yeah, we need to point out any of our work which was made by AI right now. So courts require us to pinpoint which part of our legal documents made by, AI, machines or in AI software. And yeah, I think this kind of industry practice might, well, how do you call? Affect a lot in terms of compliance. And also, I think I read somewhere about EU legislation also requires certain entities to identify AI created technologies and use of AI. I mean, so yeah, I think most of the international entities don't really know what's really going on right now, and I think law firms trying to catch up with this issue. But yeah, it's very diverse right now and unsettled. So what would you recommend to lawyers, law firms right now?
Sure. Well, it is diverse and uncertain and evolving. So some courts have adopted requirements that lawyers attest to whether they had AI produce any work product. Most do not, but in all courts that I'm aware of, their counsel always needs to attest that they, take responsibility for the contents of a brief. And so, the lawyers keep filing stuff written by generative AI and getting in trouble. And this gets judges to be concerned that they need to have rules about the use of AI. But in my view, they already have a perfectly good rule, which is you can't file something without checking that all of these citations are accurate and support your propositions. And so while there's nothing wrong with using GPT to help you write something, lawyers have to be aware that GPT is not in the business of producing accurate legal citations. Now, there are softwares that people are working on for that. Many startups are doing it. Even Lexis and Westlaw, which are kind of the US two biggest providers of legal research services, now advertise